So this is, I think, what the issue turns out to be. If you want to talk about this in sort of neoclassical property terms, the system of property rights that would develop from the time of Rome on forward essentially says about an owner is that it has not only the right to exclude, he also has the right to enter. And she also has the right to use and the right to dispose of the property. So essentially the essence of a system of property rights under the classical liberal system is one which says that every useful attribute of any physical or intellectual asset can be uniquely appropriated to one individual, such that A, you have compatible uses at the outset, and B, you facilitate ordinary markets by giving the right to dispose of property. At that particular point, the government's discretion is to make sure that this system of rights works, so you could tax to enforce it, you could put recordation systems in, you could put statutes of frauds in, anything which will stop the problems of double dealing or the problems of physical invasion. This is all fine. You get to the modern progressive era, they don't believe any of this stuff. They only see property as a form of oppression. They never see it as a form of production. So what do? They go into the RIF, which says all property is just the right to exclude and nothing more. And this becomes a modern American constitutional law when you start talking about a case of Keisner-Ettner in the late 1970s. Well, what does that mean? It means that any use of property and any disposition of property is now subject to the regulation of the state. What does this in turn do? It creates the world's most horrendous bilateral monopoly. It turns out that the government, by constitutional fiat, cannot enter the land unless it's willing to pay for it, and it never wants to do that. But on the other hand, you can't use or develop the land unless you get their permission. So you have a situation in which the value of property is, in effect, always to be contested because the use and disposition rights of a piece of land may be worth, conservatively, anywhere between 98% of its total value or down as little as 5 or 10%, depending on what's going on. What the administrative state does is it says that every one of these use and disposition rights is now subject to some form of collective deliberation, for which, in effect, the state which decrees is not the state which has to compensate. And so what you do is you now create what is clearly the most dangerous situation imaginable, is you've created a situation in which power is completely separated from responsibility. The ability to designate this land as a wetland, to designate this as an endangered species habitat, to designate this as a special monument for precaution can be done through the political processes. The consequences to the owner are simply a byproduct of the great deliberation. What does this then do? Well, it leads to very odd behaviors. If, in fact, there are really pronounced externalities for which you are not going to bear the cost, you will always be willing to engage in activities at your own expense, ignoring the cost to others. What does this do? It actually creates the wrong kind of moral character. Because instead of having people saying, look, I'm willing to do something for my benefit so long as I compensate those whom I compromise, you have people figuring out, how can we work a deal so as to essentially circumvent those whom we hurt by forming a winning alliance amongst those who we like? And so you get all sorts of zoning type things that take place, in which there's an exclusion here for the benefit of the developer there. You get rent control type situations, all of which is subject to administrative discretion.